participant in the common purpose to rob, who had physical control of a weapon, intended to not merely use it, but also to possess it, both for himself and also on behalf of one or more other participants, and each alleged joint possessor, who did not himself have physical control of a weapon, intended that one or more of the weapons should not merely be used, but should also be possessed by another participant on his behalf. Before applying these principles to the facts of the present matter, it is necessary to consider the presumption created in Section 1172 of the Firearms Control Act, the relevant portions of which read as follows. I have already read this into the record. That is, wherever a person is charged in terms of this act with an offence of which possession of a firearm or ammunition is an element, and the state can show that despite taking reasonable steps, it was not able to, with reasonable certainty, to link the possession of the firearm or ammunition to any other person, Your Worship. This has not been done. Your Worship, I'm going to move on from there down to the following page, where I have a highlighted portion. This finally brings me to the question whether the state, not being aided by the presumption, has proved joint possession of the firearms by the occupants of the BMW. In my view, at best, for the state, the accepted evidence shows that occupants of the BMW were all aware of the presence of the firearms in the vehicle. That, however, is not sufficient to find that the occupants possessed the firearms jointly. Mere knowledge of the presence of the firearms, as rightly conceded by counsel for the state, is not sufficient to establish joint possession, which is my emphasis. We're moving on to paragraph 46, Your Worship. I am unaware of where or whether the vehicles were found, where the firearms were found, and in whose name the vehicle is. The information is presumed to form part of the state's case, but I am unable to comment further on same, bar for asking whether the state lifted fingerprints from the steering wheel and matched it to any of the accused to assist the court in same. Count 11 is not preferred against me. Count 12, money laundering, is at this time somewhat difficult to answer to, in that I suspect that receipt of any funds by myself before or after the incident will be presumed to be funds that originated from unlawful activities and related to the incidents at counts 1 to 10. I, however, submit that me having had knowledge of the source or origin of deposited or received funds at any time is simply brevity on the part of the state. Cash payments, trading stores, and electric transfers occurred daily.
Is it my understanding then, therefore, that at this point in time, applicant number 2, 4, and 5 are not ready to move their application because their affidavits are not ready, and that would be done on the next appearance?
On behalf of applicant number 5, I confirm the position, Your Worship.
I confirm the position, Your Worship, and also the fact that at 1 o'clock the court has to close. We don't have any option.
All right. This, first and foremost, the issue raised by Mr. Volmarans with regard to the seized vehicles, I have no information of that. There is no application brought before me with regard to that. I'm not in a position to entertain that because there is no application before me. I'm not going to deal with that. And at this point in time, the matter is postponed on to an agreed date, which is the 18th of March, next week, Monday, for further proceedings. Applicant number 1 to 5, please rise. Matter against you is adjourned until the 18th. You'll be kept in custody at Westville Correctional Services or Correctional Institution until then.
That will then, Your Worship, complete our role for today.
Corrections.
Rise.
Once I've got you on WhatsApp, then I can transfer it to my left. Okay, thanks, Lawrence.
Okay, thank you.